Hi. Actus reus is the first key element of criminal liability you need to understand for A-level law. You need to understand the difference between actus reus and mens rea, the three types of crime in relation to actus reus, and the importance of voluntariness. You also need to understand the rules on an omission as actus reus. Actus reus and mens rea are elements of criminal liability. A criminal offence is made up of more than one thing that the defendant has to do or be thinking in order to be liable. And these requirements of an offence can then be divided up into actus reus and mens rea, the prohibited conduct of the offence, the actus reus, and the guilty mind or the state of awareness the defendant must have while they're doing it, the mens rea. If you're revising this after you've studied the property offences, you'll recognise this as the definition of theft. So theft is the dishonest appropriation of property belonging to another with the intention of permanently depriving the other of it. This comes from Section 1 of the Theft Act 1968, and you can see that the word actus reus and mens rea don't appear anywhere in it. But we can also see that there are multiple requirements of theft, and if we divide theft into the things the defendant must do and the things the defendant must be thinking while they do it, we end up finding the actus reus and the mens rea. So the actus reus in blue is that the defendant must appropriate something. The thing they appropriate must be property, and it must belong to someone else. While they're doing it, they must be dishonest, and they must have the intention of permanently depriving the other of it. Once we've divided up the offence like this, it becomes much easier to construct a defendant's liability. It's also useful to you when you're memorising criminal offences, because it provides you with two lists of requirements for each offence. Once we understand the basic principle of actus reus and mens rea, we can categorise crimes based on their actus reus requirements. The three types of crime here are conduct crimes, consequence crimes, and state of affairs crimes. Conduct crimes are crimes where the actus reus is made up just of conduct or of a particular behaviour. So these might be called doing crimes, and once the defendant has done something with the right mens rea, they've completed the offence. Consequence crimes are crimes where the actus reus also includes a prohibited consequence, something that's not allowed to happen as a result of the defendant's conduct, so these might be called causing crimes. State of affairs crimes are crimes where the actus reus is simply being found in a particular situation, so these could be called being crimes. Now each category makes more sense with an example. If we work from the third category upwards, an example of a state of affairs crime would be the possession of illegal drugs. To be liable for possession of an illegal drug, the defendant doesn't have to do anything with the drug. They don't have to take it and they don't have to sell it. They just have to be found with it. Consequence crimes include murder and GBH. A defendant hasn't committed murder if the victim isn't dead. So the prohibited consequence of death is part of the actus reus of the offence. An example of a conduct crime is theft. The actus reus of theft, as we've just seen, is the appropriation of property belonging to another. There's no requirement in the offence that the victim actually lost anything as a result, so there's no consequence rolled into the offence. The first key rule of actus reus is that in almost all circumstances, the actus reus must be voluntary. Now this feels like it overlaps with mens rea, and it does, but really it's a rule of actus reus. It means that if the defendant didn't act voluntarily, there is no criminal liability. In Hill v Baxter, the example was given by the judge that a driver wouldn't be liable for dangerous driving if their driving was affected by a swarm of bees getting into the car. In circumstances like this, the actus reus, driving dangerously, isn't done voluntarily, so the driver wouldn't be liable. A good example of the need for the actus reus to be voluntary comes from R.V. Mitchell. So in R.V. Mitchell, the defendant punched a 92-year-old man during an argument in the queue at the post office. The elderly man then staggered backwards and fell into an 89-year-old woman, and the woman was knocked over and later died of her injuries. Now you probably know that the defendant was liable for unlawful act manslaughter because it was his unlawful act of punching the elderly man that caused the victim's death. But here we're interested in the elderly man in the middle. If he had chosen to bump into the victim and then she died, he could have been liable for unlawful act manslaughter. But him bumping into the victim wasn't a voluntary act. He only did it because the man had punched him. So the actus reus wasn't voluntary and he wasn't liable for any offence. So we know the first key rule of actus reus, that it must be voluntary for there to be criminal liability. This rule applies to the vast majority of offences and applies to all the offences you'll study in detail for A-level law. But there are exceptions to the rule. Some state of affairs crimes are crimes of what we call absolute liability. These are crimes where there's no need for the actus reus to be voluntary. Now, these offences are controversial because they can lead to prosecutions of people with absolutely no fault, where not only was the defendant not reckless or negligent, they didn't even choose to be in the situation they've been prosecuted for. A good example that shows both the exception to the rule and the reasons why it's controversial comes from R.V. Larsener, a case involving a charge of the defendant being found in the United Kingdom after she'd been refused permission to stay. But the defendant had been forcibly removed back to the UK by the Irish police, meaning that she had absolutely no choice but to commit the offence. Now, Larsener was convicted because the offence was one of absolute liability. But it's important to remember these are very rare exceptions. The general rule is still that the actus reus must be voluntary for there to be criminal liability. Before we move on to our second key area of rules on actus reus, let's read this scenario. At a village cricket game, a ball hit Olivia hard on the head. She collapsed on the field. Olivia's husband, with whom she'd recently been arguing, was watching the game but laughed about the incident with his friends in the crowd. One of Olivia's friends, who was also playing in the game, was trained in first aid but decided not to help. The organiser of the game had noticed the day before that the first aid kit in the pavilion was missing, but had not replaced it. When someone called the village doctor, the doctor knew it was nearly the end of his shift and ignored the call. Due to the delay in receiving treatment, Olivia suffered serious brain damage. Now, you might notice that what most of the people in this scenario have in common is that they failed to act. After the person who threw or hit the cricket ball, nobody else has done anything. And that leads us into our second key rule. This rule is based on the difference between a positive act and an omission. Most criminal offences are committed by an act from the defendant, punching someone in the face, stealing someone's watch, smashing a window, etc. But the law also has to tackle situations when harm is done or harm is caused by someone's failure to act, and the law calls a failure to act an omission. The general rule on omissions is that an omission does not normally make someone criminally liable. A 19th century judge summarised the rule with this famous scenario. Person A sees person B drowning and is able to save him by holding out his hand. A abstains from doing so in order that B may be drowned. A has committed no offence. Now, this makes England and Wales different from some other countries, like France, that have what we call Good Samaritan laws that require people to act to prevent harm to others. What this means is that at first glance, those people in our cricket game scenario wouldn't have committed any criminal offence because their omissions can't make them criminally liable. But there are some exceptions to this general rule. An omission, a failure to act, can make someone criminally liable if they have a statutory duty to act and they fail to do so. They have a contractual duty to act and fail to do so. They have a duty to act from a relationship and fail to do so. They've voluntarily taken on a duty to act and they fail to do so. They have a duty to act from an official position and they fail to do so. Or they've set in motion a dangerous chain of events and then fail to act to stop it. We'll work through the list of exceptions one by one. The general rule that an omission doesn't create criminal liability comes from common law, but we know that Parliament is sovereign, so Parliament can use statute to make exceptions to this rule. One example is the Road Traffic Act 1988, which makes it a criminal offence not to stop after having a car accident. The accident itself isn't necessarily criminal, but the omission of failing to stop is. A second example comes from the Children's and Young Persons Act 1933, which includes offences like neglect or a failure to provide for the needs of a child. Our third example is more recent and a bit more unusual and comes from the Domestic Violence, Crime and Victims Act 2004. This is a more unusual example, which makes someone criminally liable if they're an adult living in a house where domestic violence is taking place and they fail to take steps to protect the victim, such as by calling the police. A criminal omission can also come from a duty written into a contract. This applies mainly to people who do jobs that could have potentially disastrous consequences if someone doesn't fulfil their duties. In RV Pitwood, the defendant was a railway crossing keeper whose job was manually to open and shut the gates at a railway crossing. He was convicted of manslaughter when he failed to shut the gates and it led to someone's death. Even though he didn't act, it was an omission, he failed to close the gates, his contractual duty meant the omission amounted to a crime. This category is similar to the contractual duty to act, but instead comes from a defendant's official position as a police officer, as a government minister, or someone like that. In RV Dytham, the defendant was a police officer on duty who failed to intervene in a fight while he was on duty. Dytham was charged with misconduct in public office, but defended himself on the grounds that misconduct requires him to have done something, and he didn't do anything. The court rejected this. Dytham was convicted of misconduct in public office. He had a duty to act from his official position as a police officer on duty, and his failure to act amounted to a criminal omission. But even without a contract or a statutory duty, a duty to act can come from a relationship. Although the Children and Young Persons Act put this duty into statute, parents already had a duty to care for their children under the common law. We see this in Gibbons and Proctor, where two parents failed to feed one of their children. They did it deliberately, and that led to the child's death. This led to the parents being convicted of murder, even though there was no positive act that killed the child. Because of their duty as parents, their failure to feed the child was enough for the actus reus of murder. What if the defendant isn't a parent and doesn't have a contract or a statutory duty, but they've chosen to take on responsibility for something? This can still create a duty to act and the possibility of a criminal omission. In Stone and Dobinson, the two defendants voluntarily took on responsibility for looking after Stone's elderly sister, who then died after they failed to feed her. Both Stone and Dobinson were convicted of manslaughter. Their omission in failing to feed the victim amounted to a crime because they'd chosen to take on the responsibility for her. The same could apply, for example, to someone who volunteers to babysit for a friend's child. A variation on a defendant having voluntarily taken on a duty comes in situations where the defendant's not consciously chosen to take on a duty to act, but has voluntarily done something that sets in motion a dangerous chain of events. In these circumstances, the defendant may have a duty to act and could commit a crime by not acting. In Miller, the defendant was charged with arson. He'd fallen asleep with a cigarette in his hand, and this led to the mattress catching fire in a flat that he didn't own. When he woke up and saw the fire, he simply moved into another room and went back to sleep. The key to understanding this case is to understand when the arson took place. The arson didn't occur when he dropped the cigarette while he was asleep, but it occurred when he failed to put the fire out or to call for help. Having set in motion this potentially dangerous chain of events, i.e. by smoking and then falling asleep, Miller had a duty to call for help once the fire started. Now remember that all of these are exceptions to that general rule that an omission doesn't make someone criminally liable, but the exceptions are that an omission can make someone criminally liable if they have a statutory duty to act and they fail to do so, like the failure to stop after a car accident. They have a contractual duty to act and fail to do so, like Pitwood, who was employed as the railway crossing keeper. They have a duty that comes from a relationship and they fail to act, like the duty of a parent to feed a child. They have voluntarily taken on a duty to act and they fail to do so, like Stone and Dobinson, who volunteered to look after Stone's elderly sister. They have a duty to act from their official position and failed to do so, like Dytham, who was the police officer on duty who failed to intervene in a fight. Or they've set in motion a dangerous chain of events and then failed to act to stop it, like Miller, who failed to call for help after accidentally starting a fire. So let's return to that cricket game and all the people who failed to act to help Olivia after she was hit on the head with a ball. Use the rules on omissions as actus reus, including the exceptions we've worked through, to decide which of the people in the scenario might have committed a criminal offence by their omission. Remember to back up your thinking with points of law to support it and cases or statutes that would provide authority for your points. You should now be able to explain the difference between actus reus and mens rea, to give examples of conduct crimes, consequence crimes and state of affairs crimes, to explain the general rule that the actus reus must be voluntary and to give an exception to that rule, and to explain the rule that an omission doesn't create criminal liability and explain each of the 6 exceptions to it. Hit subscribe to get notifications on new tutorial videos and follow the link in the description to lawstudyclub.co.uk where you can find up-to-date revision guides and more resources for the OCR and AQA specifications or to inquire about tutoring for A-level law.